Great. Welcome, everyone. Welcome again to this intellectual property webinar. Thank you for joining us. Before I hand over to Rina and Anand, I would like to do a few housekeeping rules to make sure that your experience today is the best possible. So when the presenters are speaking, we would like to ask you to mute your microphones and turn off your cameras, not to disturb others. But during the session, you will be also working in groups and speaking with others. So you are encouraged to unmute yourself then and contribute as much as you can. We also welcome any questions. So please use the chat function to submit the questions, because at the end of the workshop, we will have a short Q&A session. Also, to help others identify you and address you, we would encourage you to change your name here on Zoom to your full name and possibly your company's name for the best experience for everyone. So before we start, I would like to hand over to Bao, our head of ventures, for a quick welcome and hello. Over to you, Bao.
Thank you, Carolina. So yeah, I just wanted to say my name is Bao Chu. I've recently joined MSD UK as head of ventures. So I moved over from UCL Innovation and Enterprise, where I was leading on entrepreneurship and startup incubator over there. So my remit within MSD UK now is to design and develop some really exciting initiatives and activities to support ventures, ethnic minority ventures as well. So I'm really excited, and I want to be talking about the integrated supply chain accelerator that we're developing and hopefully launching this year. We're still currently working on that at the moment, but keep connected to MSD UK to find out more. My colleague Irvin will be talking to you about other opportunities, which is the Innovation Challenge later on in this session. But really, it's just a warm welcome to introduce myself to the community. And please feel free to reach out to me on LinkedIn or through MSD UK. I'm here to help as many early stage ventures and even established SMEs through my experience, contacts, and network. And I'll hand it back to Carolina now.
Great. Thank you very much, Bao. So let's get to it. Let's get to the reason why you all came here. So today, the IP workshop will be led by Rina and Anand, and I would like to talk to you about them for a minute. So Rina is a company commercial partner, and she heads the commercial and IP team at Logmore Solicitors. She has over 20 years experience in dealing with a variety of commercial contracts, intellectual property, and brand protection issues. Rina also has specialist experience in assisting her clients with protecting, managing, and exploiting their IP assets to their full commercial advantage through licensing, university spin-outs, and other arrangements. Anand is a senior patent attorney for British American Tobacco, where he leads freedom to operate activities for one of the company's most challenging and rapidly evolving technology areas. He is an IP strategist and is experienced in dealing with global patent portfolios, conducting due diligence in litigation procedures, to name just a few. So I hope that you are as excited as we are here. And without further ado, over to you, Rina and Anand.
Thank you. Thanks, Carolina. Right, let's just get these slides up, share my screen. Hopefully you can all see that.
Yes, that's perfect.
Great, good. Thank you for that. So good afternoon, everyone. I hope you're all well. As Carolina mentioned earlier, this is intended to be a really sort of more interactive session. So I hope you'll all get involved and have had a chance to read through the case studies that were sent prior to today's session. We've got quite a lot to get through. So first we'll start by covering the different types of IP and intellectual property available. I'm sure that most of you probably are aware of and know about the main forms of IP already, but we'll have a quick run through of these as a reminder. Then we'll look at how to plan an IP strategy and cover some of the options available for exploiting your IP. And then this will be followed by the first breakout session. Basically, we'll go through the question, we'll split the room into smaller groups and run through these scenarios, and we'll regroup and run through some possible answers. Following that, Anand will cover patent strategies in particular, and then we'll look at NDAs and legal agreements. Then come on to what investors look for in relation to IP, which is quite a key area, I think, for most businesses at an early stage, before moving on to the final breakout session, followed by some questions and answers at the end, and hopefully we'll have enough time to go through that. Now, before we start the session, we thought it would be useful just to have a quick poll and to ask you a couple of questions, just so we can gauge the level of people in the room and the level of expertise and your business is at in terms of IP rights. So if you could answer the following question, in terms of intellectual property rights and those that are registrable, which of these do you currently own? Looks like everyone's selecting their answers at the moment.
Yes, the answers are coming through. I'll give it a few more seconds and I'll share the results.
Perfect.
Okay.
Great. Okay. So most of you looking at the results don't have any registered IP rights as yet. So it'll be interesting to see as we go through the session as to the reason for that and whether it's to do with cost or just the stage that you're at in your business, or whether or not actually that's part and parcel of your strategy, that you don't really want to register any IP rights and rely on unregistered rights, which we'll obviously sort of run through. Just one more quick question before we move on to the main session.
Yeah.
For those of you that do have IP rights registered, how many of those do you have? How many of those IP sort of registered rights do you have registered? I mean, we've got a whole selection here in terms of anything ranging from just a few rights through to a large IP portfolio with over 1,000 rights. I don't know if that would necessarily apply to your business if you're early stage and in the right place, but let's see how the answers play out once you have answered, pressed the button for your option.
The answers are coming through. I'll give it 10 more seconds for everyone to vote.
Thank you.
Okay, let me share the results.
Great. Right, so obviously based on the first slide, there's most of the answers have come back with having no rights registered, and then surprisingly there's an equal number of businesses who have unregistered rights, so things like confidentiality and trade secrets, and those that have a small number of registered rights as well. So it looks like there's around 20% there of those businesses that are here today. Great, thank you for that, Carolina. So that's really interesting, and I think hopefully today's session will help to play out some of these points, and we'll talk further and have a further question for you a bit later, just to keep you on your toes. So first of all, what is IP? You know, what is intellectual property? Why is it important? It can be seen as a driver of value. It's great for a business because IP rights can essentially provide your business with market access. It can prevent the unlawful use of your work. It can build assets for creating value, including opportunities for collaborating. They can enhance your reputation and build customer loyalty. They can provide leverage in negotiations for any contracts. They can improve access to funding and investment.
Oh, sorry, Rina.
Mute there, Rina.
Oh, sorry about that. That's randomly keeps happening today for some reason. So sorry. So they increase the economic and strategic advantage and really can give you a competitive edge. And IP rights can exist and encompass rights in anything and everything that you can think of. And examples could be photographs, source code, software, research reports or methods, databases, designs, industrial processes, music, consumer brands across all industries. So you could potentially be sitting on a whole host of valuable IP assets which can be exploited for commercial gain. And a study last year showed that SMEs that have filed and used bundles of trademarks and patents and designs, those registered rights, increase their chances of becoming a high growth firm by a third, by 33%, which really does show that the value of the IP can really help to boost the growth and the ability of these firms to continue to grow. And it also shows that those businesses who do innovate and form strategies to protect their ideas early on will thrive. And we've seen obviously a lot of innovation over the last year, where due to the COVID situation, many businesses have had to change direction in order to survive. And it shows that with any crisis comes opportunities. So this slide shows you obviously the different forms of IP that are available, and we'll briefly run through these in turn. But I'll pass over to Anand just to cover the patents before I move on to the rest of them. Thank you, Anand.
Thanks, Rina, and hello, everybody. Just before I do touch on patents, I've always loved a definition given by the World Intellectual Property Organization of intellectual property, and I haven't got it down to a T off the top of my head, but essentially it talks about intellectual property being creations of the mind which are protectable by law, and it's always worth bearing in that in mind. And that's what we're trying to register and protect, is the creations of the mind. We want to register and protect those to prevent other people stealing your ideas, essentially. Now, as Rina touched upon, there are different forms of intellectual property which are applicable for different types of creations. So the first one is listed here is patents, and this is the non-exclusive list, by the way, but patents are mainly my field of expertise, as it were, and usually you want to think about patents when you've got an invention, and an invention in the sense that if there's a functional benefit, so it could be a product or a service, for example, and some of the qualifying criteria to get patent protection is that your invention must be considered new over anything publicly available anywhere over the world. It must be considered inventive, and this is a test which is applied by patent examiners in different patent offices around the world to assess your invention. And what they essentially do is they look at what's already known and they compare your invention to what's known, and they decide whether your invention would be considered inventive or not over that. And it needs to be industrially applicable. What that essentially means is you can't have something theoretical that isn't proven. Perpetual motion machines, for example, it defies the law of physics, so you wouldn't be able to get a patent for something like that. Patents are an application procedure, so you actually have to file your application before, for example, the UK Intellectual Property Office. It then takes several years for as many as 3 years to 4.5 years to go through that application process before the UK Patent Office for them to examine your patent application. And after that, if it's granted, you then have to pay renewal fees to keep it alive. And you can pay renewal fees up to a maximum of 20 years. And what I would do just quickly is later on in the list, you've got confidential information and trade secrets. And one of the things you'll need to consider as a business is when do you actively register a patent application and try and get patent rights versus keeping something as a trade secret. And the reason that question comes up is as a consequence of the application procedure, your invention and your application will be published by the Patent Office after 18 months since you filed. So obviously, if you're going to submit a patent application, but you want to keep it from the world, and you don't want to be limited to your 20-year protection by a patent, and for example, like Coca-Cola and KFC, you can keep, as long as you keep your trade secret, you can have potentially indefinite length of protection because nobody will have access to that information, in contrast to a patent where you've got a maximum term of 20 years. There's a lot to get through, so I'm going to stop there and hand back to Rena.
Thank you, Anand. Moving on to the next one, which is trademarks. So trademarks are generally used for brand identity and serve to distinguish a trademark owner's goods and services from those of their competition, those of others. And a trademark can be can take various guises. So it can be a word, it can be a logo, it can be a combination of those. They tend to be the most common form of marks. Trademarks can be unregistered or registered. So you can use a logo as an unregistered trademark in the course of your business, or you can choose to register it, which gives you stronger protection. Trademarks can also be things like slogans. So for example, L'Oreal's "Because You're Worth It," you know, McDonald's "I'm loving it." It can also include things like sounds, such as the MGM Lions roar, that's registered as a sound trademark. And it can also include corporate colours. So you may be aware of the infamous Cadbury's purple and the battle that they had in court over the exclusivity of that shade of purple for their particular brand and for confectionery in general. Trademarks are a great form of protection because you can apply them to potentially most businesses where you've got a brand, and they can be renewed every 10 years. So that potentially that trademark protection can last forever. And to be capable of being registered as a trademark, your word or logo, whatever you choose to trademark, has to be distinctive. So it can't be descriptive of the goods or services that you're looking to sell. And that's a common issue, that lots of businesses will come up with a business name or a brand name, which is quite descriptive. And you know, a typical example could be like the Good Soap Company, or something that's really quite obvious, and it's quite a generic and bland sort of name, and it's not distinctive enough to distinguish the business in that name from the competition. So it would fall foul of that criteria. And also it shouldn't overlap or conflict with any other trademarks that are already registered, because the purpose of having a registered trademark is that it gives you exclusive rights over that mark. So if somebody's already beat you to it in getting their mark registered first, then they may be able to prevent your mark from being registered. So you do need to be careful and do some searches at the start. Design rights are quite a similar system to trademarks, but these protect a product's visual appearance, and that can be for the whole or part of a product, and it can entail colours or shapes or texture. Examples would be things like cartoon characters, the Lara Croft character, for example. It could include furniture, surface patterns, which could be applied from anything to wallpaper to stationery, and other merchandise, and so on. And the owner of a registered design is basically provided again with an exclusive right for a limited period of time, up to 15 years, to make, use, or sell any article that that particular design is applied to. Moving on to copyright, it says what it does on the tin to a certain extent. It's the right for your work not to be copied. It's one of those rights that, again, can apply to most businesses where they're creating original work and there's a certain amount of skill and labour and judgment that's been involved in the creation of that work. And again, copyright can apply to literary, dramatic, musical or artistic works. That includes sound recordings, films, broadcast, books, and so on. For businesses, copyright could include things like books, source code, business documents and business plans, website copy, photos, and so on. And in most cases, the copyright will last for 70 years after the death of the author. In order to see and sort of show that you are are an owner of copyright, you can use the C symbol and a circle to put people on notice that the work is your own copyrighted work. And you can also monitor the market and make sure you stop anyone else from copying your work by setting up things like Google alerts for your keywords or for your brand to ensure that there's no one else out there using something that is your copyright or your trademark. Again, it's a good idea to keep records of any documents that you create, including earlier drafts, and make sure they're dated so that you've got a proof of the ownership of the copyright and those particular documents and so on being yours. Confidential information and trade secrets. So Anand has touched on this very briefly, so I won't spend too long on it, but it's essentially any form of information which you would want to keep secret and will only last for as long as that information is kept secret, and often it will be protected by way of a contract being put into place or an NDA, which we'll come on to later, which secures the confidentiality of the sensitive information. As Anand's mentioned, examples could be things like, the Coke recipe, but it could also apply to manufacturing processes. It could also apply to cosmetic skincare formulations and so on. Database rights is similar to copyright, but just applies to databases. And there are other forms of IP rights that are registered as well and available. Even domain names sometimes are seen to be sort of a form of IP right, but we won't be focusing on those too much today. Moving on to the next slide, I've included in the slide deck, which will circulate after the session, the list of IP rights, or the main IP rights which are capable of being registered. And this slide just provides a general indication of the average costs and timeframes involved in getting these particular rights registered. I think, Anand, did you want to mention something about the patent costs and the fact that those are quite prohibitive?
Yeah, absolutely. So one thing to bear in mind is that registered rights tend to be geographic rights. So if you want protection all over the world, you need to register in the markets that are key to your business. With patents, the costs, the official costs can be quite low, but you tend to need a patent attorney to draft the patent application because it's quite a complicated document. And over that 3 to 4.5 years procedure, it could be anywhere between £5,000 and £10,000 plus, depending on the complexity of the procedure. Those costs are duplicative when you go into other countries, but there are some ways to manage costs in an effective manner. You don't have to pay tens and tens of thousands of pounds for one patent family all in one go. So I can touch on that later on.
Thank you. So moving on to strategy. So I'm conscious of time, we've got a lot to get through. So I will be quick on this, and if you've got questions, we can obviously answer those more specific points at the end. IP rights will only get you so far, and that's because you've got to do something with them to actually add value. And by that, I mean, you've got to commercially exploit what you've developed and actually use your IP to generate an income for the business. And that can be done through a variety of ways, which I'll cover in a moment. But essentially, the first thing is to assess what IP your business owns, otherwise you can't manage it and protect it from damage or from loss. And if you don't manage it, you can't make money from it. So you need to identify your IP, do an audit. There's tools available online to make sure that you can identify exactly what IP is owned and used in your business, and do check that you do actually own it. Often I get queries from clients about the ownership of IP and who owns the IP. In most cases, clients who have outsourced a marketing function to freelancers or other third parties, for example, to design your logo, might later find that the business doesn't actually own that IP or that logo, because even though the work was specifically created for them, the ownership of that IP or the logo would normally be the creator, the person that developed it. So they won't normally own it unless you agree it in writing that it be transferred across to your business. So that's really important. If your employees are developing IP, then that will belong to the employer. So that's the contrast position there compared to freelancers. Do assess your IP, look at what is of value or what could potentially create value in your business. Some IP can be worthless and might not be viable, so have a look at what will be viable for you, to see what is actually then going to be worth protecting. So do protect it or register those rights where it's applicable and worth protecting. It shows it's yours. It helps protect against ownership or infringement issues, and it helps you to think about future plans, particularly in terms of expanding to other countries, and so on. Do also record your IP as well. So if it is confidential, then document it, date it, keep documents and records, to build a shield against any unfair commercial practices or any infringement allegations that might be thrown your way. Keeping records can be good practice anyway, because it can help you when you're claiming tax reliefs in terms of R&D and patent box as well. So that's always helpful. Do exploit your IP. So this is the key. Do commercialize it and actively use the IP to extract value, because just having the registered IP rights won't guarantee commercial success. You've got to do something with it. Once you've got that IP out there in the market through goods or services, you've got to then make sure you're monitoring the market and the competition regularly to ensure that others are not infringing on your rights. Do check searches on Companies House, the trademarks registries, patent registries, do domain name searches, check generally in search engines. And then finally, enforce your IP where you've got those rights protected and you've gone to the trouble of registering and protecting your rights, and something does crop up, then ensure that the value of that IP does justify any moves to protecting and enforcing your rights in that way. So focusing on the exploitation of the IP briefly, there's a range of different options here, which I've listed on the slide. You can develop the IP and the product or the service yourself, taking that whole process from idea to R&D to testing and that proof of concept stage to manufacturing and then selling those products or services. This option has the highest risk and highest reward, but is a great option, obviously, if you have the time and resources to be able to develop it yourself. You can also create ideas and so on, and then actually sell the IP without necessarily getting it fully to market. Imagine you've got a box in the attic filled with unused IP. It could be something that you look at to see what's valuable to somebody else, but isn't really worth or valuable to you, and you can sell it. Lots of these larger corporations do sometimes have that and adopt that sort of approach. Next is commercializing through licensing. This is one of the most common forms of exploiting your IP, which basically means giving permission to one or more third parties to use the IP, usually in return for royalties based on the sales that the IP generates. I commonly act for clients who go down this particular route. Just a quick example, I act for one particular client who's designed and developed some amazing baby products, including sort of baby carriers and so on, and they're environmentally sustainable and they're just a great brand. And she managed to sell into John Lewis and to Boots, and it was going really well. But then she got to a point where she just wasn't growing. So we looked at her strategy, and in the end, we managed to actually strike a lucrative licensing deal with a large supplier to expand her products into the overseas US and Asian markets. And she didn't have any contacts or distribution resources in those countries, but this large company did. So she never would have been able to achieve the sales in those countries without this particular contract. So she's basically been sitting back receiving royalties for the last few years as a result of this particular contract, because of the use of her designs and brands that the big companies doing all the hard work. So licensing is a brilliant option if you lack the money and the resources and the contacts to be able to successfully bring your own IP to the markets that you would want to get into. An alternative form, which is a sort of licensing, but usually encompasses a little bit more, is franchising. So it's normally licensing with a system of how to sell. And that would normally include an established brand proposition. So that could include brands such as Subways, Domino's, Specsavers, consultancy businesses, and so on. And then joint ventures and collaborations means essentially strategically collaborating with another party to develop and market a product together. And then there's also sponsorship as well, which can often be through universities or R&D organisations. And deciding on which commercialising method to use will often depend on your business objectives and the forms of IP available. As I say, it can depend on your skills and financial resources and the market in which you operate, your short-term versus long-term goals and so on. So whichever route you choose, make sure you choose your partners carefully and get properly drafted contracts into place to protect your IP and how that can be used. And also particularly think about worst case scenarios and in what circumstances can any license be terminated if things go awry. And I'll talk more about that later. So leading straight into the first breakout session, hopefully you've all got these case studies in front of you. We will put you into small groups, and if you can have a look through this question and think about what these possible answers might be, we'll give you all about 6 minutes to have a look, and hopefully we'll be able to issue a reminder as well when that time's almost running out. Carolina, yeah, is nodding. But the first scenario is briefly this. I'll run through the question quickly before passing over to you. Is Anisha, through her company Fresher Limited, has developed an online booking system, an app called Fresher. This system allows independent beauty therapists to communicate with their clients, allowing for easy booking of appointments and taking of payments. Anisha doesn't think there's anything else in the beauty industry like it, but hasn't checked yet. So have a think about what IP rights might exist and which of those might be the most important for her. Look at what she should register and whether or not she should register any of those rights if possible, and what else she might need to think about and do before applying. And then look at what strategy she might be able to use to exploit that IP. So as I say, we'll put you into groups now, and we'll come back in 5 minutes and have a chat through the answers. Thanks, Caroline, over to you.
Right, so I'll start the breakout rooms.
Right, so I hope you found that useful just to have a chat through, and just running through the answers to these questions quite briefly, as quick as we can anyway. So what IP rights might exist in this company? Essentially, I think the main IP rights, and probably the most important we'll start with, is the trademark. So as part of the brand that she would be developing as the app business, the brand could be quite a key part of how she markets the app itself. Copyright could also apply in terms of the source code and any other information behind it in terms of the system and what she's developed. And then also confidential information could also form part of that IP as well, in terms of kind of the back end of how this all works together. Not sure if she could obtain a patent, because it's a completely different question when we start talking about patents and software, which I'm sure we can sort of talk about at the end if we have time, Anand. So moving on to the next question, should Anisha register any of those rights? So yes, I think Anisha should have looked to register the trademark. And then she should also keep detailed dated records of her ideas and the information behind the platform. And then she also ought to carry out market research, trademark searches as well, to make sure that there aren't any other third parties who already own anything that's identical or confusingly similar in terms of that brand, because it would be much easier to change the name at this stage than to start using it to later find that somebody else has already registered the brand as a trademark. So you do want to make sure that she's free to use it without causing any issues. And then in terms of the strategy, there's a whole range of options that Anisha could adopt, which I touched on before the session. That could include selling the IP. It could mean licensing the platform to users through a subscription model, for example, and taking a commission. She could even license the platform itself to other people who then sell it on in return for royalties. She could collaborate with others for all sorts of opportunities in that respect, and could also consider adapting the platform to be suitable for other industries, and particularly for those businesses who have the need for an appointments booking and payment system. So that could also include things like nutritional therapists, personal trainers, those sorts of small businesses that might have a need for this. She could even offer the platform as a white label offering to other industries so that they can put their own brand on the platform. So the possibilities are endless, basically, when you start looking at the details of it. Hope that was quite clear. And I will now pass over to Anand, who will cover the IP and patent strategies.
Thank you, Rina. Okay, so IP rights tend to be overlapping rights that can complement each other. So I've put, don't put all of your eggs in one basket here. If you've got a new product that works in some clever way that nobody's done before, you might be thinking of patents there, but the product might have a aesthetically appealing design that you want to protect with the design right. You might have a brand name of that product, which is it contributes to your brand value, and so you might want to register a trademark around it. Now, all of these things help you derive value from your IP. What you want to do is really determine an IP strategy that aligns to your business strategy. So as I mentioned, if you've got an innovative functional product or any services, new technology, for example, then you really want to be thinking of patents so that you can exploit value through patents. If there's aesthetic appeal, such as clothing, etc., there's designs, there's trademarks, there's copyright. Manufacturing processes is an interesting one, because whilst if you come up with a clever way of manufacturing something, whilst it may be applicable for patent protection, if nobody is going to be able to figure out what you're doing, or conversely, you can't find out if somebody else is using your own manufacturing process, how are you going to assert your rights against them? So in those instances, it might be smarter to not file for patent protection, which would be published in 18 months, like I mentioned earlier, but instead to keep it as a trade secret. Of course, if you're then wishing to franchise a business, and part of that franchise is in your recipe or the way of manufacturing something through a license model, you can license trade secrets, but you might be better off with a patent there. If you've got a brand-driven business, your strategy is brand-driven. So, for example, in the known product or service for a new brand, you want to be thinking of trademarks. For software and artificial intelligence, you can get patents for new functional technical concepts, or there may be copyright available for code as well. I mentioned a little bit about patent costs escalating earlier, and there are smart ways to stagger your costs. So you need to really understand your commercial timelines. If you've got a product or a service, when is that going to go into the public domain? How much time do you have there? When are you going to talk to investors if you need funding? You should be aiming to secure the protection, or at least file for the protection before you before those public-facing events. Be ready for investor meetings, because quite quickly after your patent filing, more costs will come in. So if you're relying on external funding and you've filed your patent application, let's say, it won't be long until more costs come in, and you'll have to find some funding for that cost. So before you go into those investor meetings, you should really have a plan prepared. You should have your IP secured, or at least your foot in the door with your applications filed, etc. And the last thing to note, which many people miss, we focus on the UK, but these protection systems are worldwide, and they do differ. The rules differ in different countries. So I wouldn't, okay, I appreciate global nuances in law. We don't expect you to know those global nuances. And indeed, if you go to a UK attorney, patent attorney, they may only be talking about UK patent law. You need to just appreciate that law is different. And for example, in the US, whilst in the UK, you can't protect your invention once you've publicly disclosed it, because as I said before, your invention needs to be new in order to have a patent. In the US, you've got a year from your first disclosure to still validly protect it. So that might open up opportunities if you've accidentally disclosed your invention publicly. Similar with design filings, they're interpreted differently across the globe. So Europe versus China, you might have a design filing which works really well for Europe, but it might be interpreted very narrowly in China. So you need to really push with the attorney and make sure that they understand the nuances. And it's notable that you can register copyright in some countries, like in China and the US. So those are just a few examples to illustrate the nuances. If we can go to the next slide, please, Rina. Thank you. So I talked earlier about aligning your IP strategy to your business model, and this is only one way to visualize. It's not necessarily suitable for all business practices, but you can think of your commercialization versus your strength of IP. Now, if you've got a low level of commercial activities, let's say you're not selling anything yet, you're a very early stage of your business, you've struck up no deals, you don't have a supply chain, you may have little IP as well. You'd be considered maybe a small fish. You don't need to worry about IP so much at that point in time. What are you going to do with it at such an early stage? Unless you're going to actively pursue licensing strategies. If you can click one, please. Now, as your commercial activities increase, and you don't develop your IP, you can become a bit of a target. So as let's say you've got a product, your sales increase, etc., you then become a threat to one of the bigger brands in the marketplace who do have IP. Now, if you're infringing their IP, they're certainly going to try and take you down. So you want to move from that over to the right to strengthen your IP. And you may as well click all the way, Rina, please. Thank you. By moving to the right-hand side of the chart, so let's start from your commercialization point. So if you've got a high level of commercial activity, you strengthen your IP, you can become a greenhouse. So you're protecting yourself from the external environment by having your portfolio, your IP portfolio, to defend your business. But you're also encouraging internal growth as well. By having IP, you're allowing yourself an opportunity to develop more products, more services, etc. And in the last quadrant, if your business strategy is to have more of a licensing strategy, you're not commercializing directly, so you're not a target to others because you've got no products in the market. You're more of a shark. So you want to look to increase your IP so that you can have more stuff to license, but you're not a threat because your level of commercialization, direct commercialization, is low. So that's just one thing to help you visualize and, think about where you are on this quadrant and where you want to be. Think about what your level of commercial activities are going to be. If you're going to increase, then you may need defensive tools. You may need to build your IP portfolio. If you're not going to commercialize and you want to generate your money through revenues, through royalties, etc., then you need not worry about the target situation, but you should be strengthening your IP portfolio so you have something to license. Thank you, Rina.
Thanks, Anand. Right, so moving on to the next topic. Now, before we do, we thought it might be good just to get just to ask one further question of yourself. So we're going to bring in the final poll question, and if you could select the answer to this that applies to you. Have you ever used or required any of the following? They're multiple choice, so you can select more than one option if you want. So NDAs, development agreements, manufacturer and supply agreements, and licensing agreements.
Great, and I can see votes coming through. I'll give it a few more seconds.
Great.
Okay, 7 people haven't voted yet. I will give you 7 seconds then. Okay, I think this is it. So I'll share the
Great.
results.
Thank you. Right, interesting. And actually, as expected with the NDA, so most of you, in fact, all of you but one, I think, have signed and said that you have signed or entered into an NDA or confidentiality agreement before. And then there's a fairly even sort of number in terms of those of you who have signed development agreements, manufacturing supply agreements, and licensing agreements. So that's all really good stuff, because it shows that you have thought about and are actually doing something with your IP, rather than just registering the rights or just sitting on the IP without actually doing anything actively with it. So that's great to see. Great. So in terms of general contracts, when you are talking to other third parties about your ideas, particularly if it's with a view to going into business with them, then obviously you've got to make sure that you do have an NDA put into place before you disclose any commercially sensitive information. And if discussions do go further and you're looking to enter into commercial arrangements with third parties, again, it's really important to ensure that you have clear agreements in place, setting out the ownership and use of each party's IP, and how that works. Now, I don't propose to go through all of the points on this slide, but do consider these particular areas really carefully when you're negotiating terms for any agreement. Where most of you signed NDAs, one of the questions I'm often asked is how can businesses protect their ideas but still be able to discuss them with others, particularly when they're looking to try and get funding? And obviously the question of NDAs then arises. As most of you will be aware, the purpose of this is to maintain the confidential nature of the information that's being shared. But also, even if they don't necessarily sign an NDA, but something along those lines is mentioned but never signed, it also increases the likelihood of enforcing any implied confidentiality obligations upon the recipient of that confidential information. If the topic of an NDA has been raised, it's sort of insinuating that there is sensitive information, that it is confidential. So that in itself, just discussing it and raising the issue, even if you don't actually sign it, has a little bit of merit, but obviously not the same full protection as actually signing an agreement. But be careful, because NDAs sometimes can't provide an absolute guarantee of protection. So it's really important to be clear about what the purpose for which you're disclosing the information being disclosed is going to be disclosed, and make sure that that purpose, or the project sometimes it's defined as, is worded in a way that is going to be reflective of what the parties are discussing, because there could be potential loopholes there in terms of other information or other purposes that the person could use that information for. So it's always useful to just check through those agreements quite carefully, even though a lot of people do tend to think of them as just being standard form. But do make sure that you take that common sense approach to them, and only obviously disclose what information is absolutely necessary as well. This leads on to whether you should ask investors to sign NDAs. A number of investors will say that they see these, they see hundreds of companies a month, and if they were all asked to sign NDAs by all of these businesses, then it just isn't feasible, because investors obviously see lots of different ideas, and for them as an investor, there's going to be a reputational and commercial risk in signing NDAs as well. For example, if a company fails on a product, but another one succeeds, in which that investor is invested, then that investor could potentially be open to a claim by the failed company, alleging that they passed the idea on, when that isn't the case. So it's sort of a risk scenario for investors, and often the reason why they won't sign these sorts of agreements. But as I mentioned, just bringing up the topic of it indicates that it is sensitive material. This leads us nicely onto the next slide, which is what investors look for in relation to IP in broad terms. So ultimately, they'll be looking for a viable business that will give them a return on their investment. And they'll definitely look at the IP within a business when deciding whether or not to invest. So obviously it's quite key, as we've explained, that businesses do need to understand what IP is and what it really means for their business. Generally, when I've spoken to investors, they have all pretty much said similar things, that there generally tend to be 3 different types of business founder: those who ignore the IP or just don't understand the nature of the IP that they've got. There are those who are the opposite and over-reg it by registering anything and everything and being super protective, even where those rights might not actually be worth protecting. For example, if they're just not commercially viable. And then there are those who hopefully will form the vast majority of you here today, who achieve a balanced and pragmatic view. So, you'll tend to take a sensible approach to it all. You'll appreciate the IP that you've got and what is commercially viable, and mark documents that you're creating with copyright notices, registering those useful trademarks, getting patent protection over the key products or processes that you're looking to create and that would be viable and which can be exploited. So it's taking a sensible, balanced approach to IP protection, in essence. And also ownership. Investors will want to see that the company owns the IP rather than any individual founder. So make sure you've got an assignment document in writing transferring the ownership to the company before it starts building up lots of value, because there could be tax implications. The different rights, obviously, as we've mentioned, cover different aspects of your business and goods and services you're developing. But the reality is that obviously early stage businesses will often be pre-revenue, limited on a budget, might not be able to afford to register any IP rights or patents. Most investors worth their salt would say that that isn't a major concern necessarily, because they could look at the competitive landscape and consider whether the business actually has any other unfair advantages, or in some cases whether that investor could actually help the business with creating that unfair advantage. In many cases, there'll be forms of IP in the technology itself that's being developed. So there can be some serious IP and patent capability, but in other cases, the unfair advantage could be seen as, a form of IP in a more kind of holistic way. For example, where a business has a really strong team or specialist skills and experience that can really give that business the competitive edge that it needs. Because when you think about it, startups will often fail because of the people rather than the technology, if that's what they're invested in. So it's really key to have strong agreements in place between business owners, as shareholders agreements and so on, but also obviously make sure that your IP is protected in a pragmatic way. So moving on to the second case study, I will pass over to Anand to run through this one, and then we will again have a second breakout room to give you time to discuss.
Great, we're bang on time here. So I just want to add a very quick note about NDAs from a corporate perspective. We've received many unsolicited ideas to, people saying, we're going to make your business so much better, give us some money. As we do invest so heavily in R&D ourselves, we don't want to receive those ideas under an NDA because it might put us in conflict. So we actually ask those people to either sign a confidentiality waiver if they want to discuss anything with us, to send us only publicly available information, or if they really want to advance discussions with us, they need to send us a patent application that's published, or any rights that they have already obtained, so that we can use that as a springboard to see whether or not we do want to enter discussions with them under an NDA or not. So just worth bearing in mind if you guys are approaching big corporates yourselves. Okay, very quickly with the case study scenario. So Zahara is a keen cyclist and came up with a new product idea of an innovative bike rack. The clever thing about the bike rack is that it's dual purpose. It can either be mounted on a wall, so the bikes can be neatly arranged and out of the way when not in use, or be detached from the wall and mounted to her car, so that bikes can be securely transported whenever she wants to go on her cycling holidays. It also has an eye-catching and unique appearance. She was excited about her idea, and essentially approached a local bike shop owner, Mr. Cheeky Git, to try and understand the market opportunity. She had a new name for her business, Bike Hike, etc. She attended the meetings and gathered that there was indeed a good market opportunity, and subsequently set up a business and started selling her bikes via a well-known online platform. A few weeks later, she discovered that Mr. Git had created and was selling an almost identical product on the online platform under a brand name, Bike Hike, only spelled differently. So discuss the legal IP and commercial consideration. I'll hand over to Carolina.
Great. So I'll move you to your breakout rooms and you will have 6 minutes again to discuss this.
Good. So, okay, let's break this question up. So the first thing to mention is Zara's come up with, we're told, a new product and that it's innovative. So we should be thinking here about a new invention, in which case there's a potential patent application there, which we could protect. Then it talks about the invention itself. Now, this is something I haven't touched upon in any level of detail so far, but in order to protect something, you actually, via a patent application, you need to describe it in a level of detail which is sufficient for somebody else to implement the idea, essentially. Now, here we're only told about, really, at a very high level idea of this is what it can do functionally. It doesn't actually say how it can be done. So there's a question here, is there enough information to file a patent application or not? We're also told that the bike rack has an eye-catching and unique appearance. So we talked about aesthetic appeal earlier, so there may be some registrable rights around the design itself as well to prevent other people from copying the specific design. Okay, so Zara decided she wanted to quit her day job and fully focus on her product idea. Now, one thing we haven't really talked about much here is it's called infringement clearance. Just because you have an idea, it doesn't mean you're clear to use that idea or that brand name or the invention, etc., because somebody else may have protected it already. They may have registered trademarks, patents, etc. So one of the important things to consider before launching any idea, launching any product, launching any brand name is called infringement clearance, or also known as freedom to operate. So Zahara should think about looking for other third-party rights to make sure when she launches her business, she doesn't infringe anybody else's rights. Okay, so she decides to approach the local bike shop owner. Immediately, you should be thinking, okay, I've got a new idea. I want to protect that idea. If I disclose it to somebody without a non-disclosure agreement or a confidentiality agreement, I'm going to jeopardize my ability to subsequently protect that. So either you want to get your protection in first, or you want to get an NDA in place. Ideally, you'd get your protection in first and get your non-disclosure agreement in place to make sure that any discussions with the local bike shop owner will stay confidential. Let's see. Okay, she attended the meetings, started selling her products via a well-known online platform. This is quite useful for anybody who sells via Amazon's, Alibaba, etc. Is that you tend to see a lot of similar products out there or copycat ideas. Now, if these online platforms have a lot of powerful abilities to take down those infringing websites, but they won't do it unless you have a registered right. So even if you've got a very narrow registered right in scope, so it doesn't have a broad scope of protection, you could potentially register that if you're going to be selling something online on an online platform. So that's something well thinking about. Okay, so she discovers Mr. Git had created and was selling an almost identical product on the same online platform under a very similar brand name. So this goes into enforcement of rights. So almost identical product. What rights do you have? Do you have a patent? Do you have a registered trademark? Registered design, which protects the appearance. Can you use those on the online platform to have the infringing site taken down? And can you stop Mr. Git from using the potentially infringing trademark? So that's probably where I'll leave it for now, to leave enough time for Q&A. But hopefully that gives you a good insight into how you might think about all these overlapping rights and best business practices. I'll hand it back to Rena.
Thank you. Thanks, Naz. So we've included in the slide pack a bonus case study for you all, just in case you fancy thinking about some other IP sorts of scenarios. And we will, as I mentioned, circulate a copy of these slides after the event, which will contain some of the answers and the pointers that we've discussed today, including some of the potential points that could be covered in response to this bonus study. So before we go into questions, I mean, just to conclude, so as we've seen today, there's a number of ways to make the most of your IP and really use it to help grow your business and your bottom line. And the key to doing that effectively is to obviously understand what IP the business owns and develop and maintain an IP strategy, manage your IP well, be conscious of the different options available, and then go out and exploit them. As you will have learned today, whichever method of commercializing your IP you choose will depend obviously on a number of factors. And so we hope today's session has given you some food for thought. And obviously, if you should need any help following the session, do feel free to contact us or connect with us on LinkedIn. But for now, we'll take some questions if anyone else wants to put anything else into the chat box.
Yeah, and I can see that Liam has his hand up. So Liam, would you like to unmute yourself?
Yeah, I just gonna ask, how do you put forward to the NHS or hospitals, for example?
Sorry, sorry, I didn't quite hear the question.
How would I put forward to the NHS or the hospitals, for example?
What do you mean by how would you put forward?
Put an idea.
An idea forward.
An idea for the hospitals.
So it very much, I think, depends on what the idea is, and I guess it would be a case of finding out who the right contacts or connections within the NHS would be. You'd have to probably just do some research to try and work out the best route or the best avenue to kind of reach the right person to begin with. And just make sure that if it's an idea that you wouldn't want to be copied, that you think carefully about the level of information that you would be providing about your idea. And also consider obviously having some sort of an NDA agreement or something put into place before you disclose further details beyond just the idea itself. You obviously don't want to give away too much information without that confidentiality being in place, so that somebody else can just go off and use your idea for themselves. So it's a tricky one, but if you can get it into some sort of contractual obligation so that they don't just steal your idea, then it could be useful into being able to discuss those ideas without fear of those being stolen or used elsewhere.
Thank you.
Great, and I can see that Lindsay has her hand up. I saw, Lindsay, that you posted a few questions as well. So feel free to unmute yourself and ask the question.
Thank you. Yeah, I'll go for the first question I've asked, and I won't ask all of them because I'm sure you want to give everyone a fair chance. So I'm a TV and film producer with my company Connect Productions, and I've optioned the rights to create projects, to produce projects that are created by other people. This is great, and I've done it for a few years, but I haven't got to the stage yet where I've been asked by a creator for a profit share is there a standard kind of formula that I can use to negotiate the percentage of profit share that the creator gets with the production company?
Good one. Interesting. I suspect that there probably is an industry sort of standard or norm, but I probably haven't dealt with enough of those sorts of businesses in that industry to be able to give you any sort of definitive answer on what sort of level of profit share would be the reason, would be seen as a reasonable one. I probably try and tactically try and find out through doing some research, if you're able to, or reaching out to other connections in your network to try and gauge that information perhaps, or try and put the onus on the other party to say what they're willing to offer, and then kind of work backwards from there, and try and, obviously they're going to start with a low percentage for you and a high percentage for them. And obviously you're going to want to try and push back on that as much as you can. But obviously it's useful to have a gauge of what the norm or what the standard might be. But unfortunately, I don't know it offhand. So sorry about that.
Okay, thanks.
Right. And Sam, your hand is up. So would you like to unmute your microphone?
Hi, yes. A quick question. Actually, we run a coaching and learning platform. It's quite online and software based. So right now we are considering how we're gonna, whether we're gonna go with the copyright or software patent aspects, when it comes to our workflows, and also protecting our coding. A couple of things to mention, because the way we store data and capture the data and retrieve them is quite different to our competitors. The second part is the workflows that we have developed is quite unique in terms of how coaches and mentors operate in our their businesses on our platform. So we're considering which way we should go from whether it's copyright or software patent, or any other ideas you have to protect our platform. Thank you.
Anand, do you want to jump in on this one, on the patent side?
I can do. There's quite a lot to carve up there, and I'd say you'd probably, it's a bit of a cop-out, but you'd need to have a detailed discussion on this. One of the things you need to consider is what have you got, first of all? What can other people establish? Now, if the ways of accessing data or managing the data, etc., are all kind of hidden from everybody else, what's the use of protecting that if nobody's going to be able to establish how you do it? On the other hand, if it is something technically new and provides a benefit which nobody's thought of before, and somebody can kind of reverse engineer or tell how you're doing it, then you may wish to consider protecting it using patent protection. Copyright will automatically arise in the code anyway, so you don't need to think about actually registering that copyright. But it's quite a loaded scenario, and there's certainly some discussion to be had there, but not in a couple of minutes, I'm afraid. So that's probably as much as help I can give right now.
Sure, thank you, Anna. I'll probably be in touch with you guys then. Externally. Cheers.
Sure.
Great, and I picked up one question from the chat as well to give visibility to both channels. So a question from Tiggs: what sort of costs are associated with trademarks?
So it varies depending on obviously which countries you would want to protect your trademark, but for the UK it's relatively inexpensive as a starting cost. Your filing fees will start from as low as £170. That's if you were going to aim to try and register it yourself. If you were going to use a trademark attorney or IP solicitor such as myself, you can get somebody to take over the whole process for you. And they will charge the filing fees, but also their own legal costs or professional fees on top. Those will vary from firm to firm, but generally you could look at £400 or £500 per application, upwards of that. It very much depends on the numbers of applications you want to register, which classes you would want to register in, whether or not you would be looking to register any trademarks as a series in one single application. There's different options basically that would affect the cost, and obviously that could increase from there, but the starting point is £170. For a European-wide trademark, costs start from around €850 in terms of filing fees. And then the worldwide trademarks go upwards from there. The broader the protection in terms of the further afield you're going, generally the longer and more expensive the price and the process gets.
Great, thank you very much, Rina. So I think this brings us to the end of the Q&A session. I can see there are many questions in the chat, so what I will do, I'll collect them and we can follow up with you individually. At the moment, I would like to thank you both, Rina and Anand, very much for joining us today and sharing your knowledge and expertise with our audience. Thank you very much.
Thanks for having us.
Thank you.
Great. And now I would like to hand over to my colleague Erwin, who will talk to you about what's coming up for our community and about opportunities that you can get involved in.
Thanks, Carolina. Let me just share my screen with you. Just 1 second. And I wanted, can you see it? Can you see my screen? Yeah.
Yes, we can see. If you could just make it full screen.
Brilliant.
Perfect.
Okay. Hi, everyone. My name is Erwin Picari. I'm a program manager at MSD UK, and I want to talk to you about the Innovation Challenge, which is a pitching competition that will open on the 1st of April. I'll make this really quick because we are very pressed for time. So the Innovation Challenge, as the competition started in 2017, it is on its 5th year now and it's been growing year on year. This year, however, we've decided to change from what we've been doing in the past, and this year's theme is Better Ideas for a Better World. And the focus for this is to mitigate some of the challenges that we face in the world today, such as climate change, social injustice, political turmoil, and others. We got together with our corporate sponsors, and each of them contributed in providing us with a theme, and this year's themes are aligned to the UN Sustainability and Development Goals. And this fits very well with our corporate members' agenda because they are also trying to make a difference and change the world for the better. Now, for those lucky few that will win the competition, they will have a fantastic chance to work with our sponsors and to be mentored by them, and this will help them grow and develop their company. The competition is open to startups and SMEs, and at MSD UK, as you know, we work and support ethnic minority startups and SMEs. So the competition is open to ethnic minority-owned startups and SMEs. These are the challenges or the categories that we have. So we've got advanced digital solutions from sponsored by Digital Catapults, healthcare and well-being sponsored by GSK, social innovation is sponsored by EY, and we've got energy and net zero carbon sponsored by Accenture, and facilities and smart buildings by Cummings. We've got some fantastic prizes this year. So £5,000 cash prize for the overall winner, £40,000 worth of scholarship at the Ivy League Tech Business School in the States, and £100,000 worth of mentoring from one of our corporate members, Accenture. And let me move to the next slide. So if you are interested, you're a startup or an SME, please scan that barcode. I'll put my email address on the chat and drop me a line, and we can talk about the challenge further. Let me tell you also what's coming up. So we got the pitching workshop coming up on the 29th of April. Our lovely Carolina here will manage that. And last but not least, I think this is a fantastic opportunity. MSD UK is offering a 3-year membership, which will end on the 31st of this month. So I would urge everyone to take advantage of this. And let me tell you a bit about MSD UK. We're a non-for-profit organization, and we are part of a truly global network with sister organizations in Canada, South Africa, Australia, China, and the US. And if you're an ethnic minority SME that's looking to export, we can help you with that because of our connections globally. But we also provide support for ethnic minority-owned businesses and startups in the UK. So if you apply, you will be able to attend all our events, our networking events, workshops and programs for free. So do take advantage of this fantastic opportunity, as it's not going to last long. So thank you very much for your patience, and I want to thank Rina and Andan for the fantastic workshop. This is the second year that we're doing this, so it's come back by popular demand. Thank you very much, and that's all for me. Thanks.
Great. Thank you very much, Erwin. Thank you again, Rina and Anand. And thank you to all of you for joining us today. We will follow up with the materials and information and the recording. And if you have any questions, please get in touch with us. Thank you very much.